purview of personal data in Indian legal framework. Existing legal framework. Currently, India regulates the use of data under the Information Technology Act, 2000, which was amended in 2008, as well as rules made under the IT Act, such as information technology, reasonable security practices and procedures and sensitive personal data or information rules, 2011, SPDI. Recently, India's Union Cabinet approved an amended version of the Digital Personal Data Protection Bill, 2023, DPDP, which proposes to replace the existing data protection framework. Moreover, the EU's General Data Protection Regulation, GDPR, also has an impact from a global perspective. How personal data is defined? The GDPR defines personal data as any information relating to an identified or identifiable natural person. Under the GDPR, such a data subject can be identified directly or indirectly by reference to an identifier, such as a name, an identification number, location data, an online trail, etc. Also, one or more factors specific to the physical, physiological, genetic, mental, economic, cultural or social identity of a natural person. India's existing data protection framework specifically stems from the IT Act, read with the SPDI rules. These define sensitive personal data or information as that which consists of information relating to items such as passwords, financial information, health and medical records, biometric information, etc. The DPDP defines data in line with the IT Act. It is further refined by including opinions within the scope of the information presented and by adding elements such as the appropriateness, interpretation or processing of communications by humans or by automated means. Under the DPDP, an individual has the right to have their personal data rectified if it is inaccurate or misleading. Elements needed for data to relate to an individual. Information can be considered to relate to a person when it is about that person. In many situations, this relationship can easily be established. Presence of three key elements, content, purpose, or result, may indicate that the data relates to an individual. Firstly, the content is deemed present where information about a particular person may be available, regardless of the purpose or impact of such information on the individual concerned. Then, the element of purpose may be invoked when some valuable information relates to a particular individual and which a data fiduciary or third party intends to commercially exploit. It may exist when personal data is prone to be used for the purpose of evaluating, compromising, commercially exploiting and/or influencing an individual's status, preferences, profile or behavior. Finally, data may relate to an individual when its use may affect their rights and/or interests. Here, the element of result comes into play. In this respect, it may not be necessary for a major impact on the potential outcome, as long as the processing of the data may result in one individual being treated differently from another. However, the presence of any one of the elements is sufficient to ensure that the information relates to a specific individual. Therefore, processing of such information could be subject to data protection rules. Any questions? Ask C-Quel.